Hello everyone, welcome you all for today's discussion. Today we are going to see Indian polity prelims practice question SET2 based on M.Laxmikant. Let us begin with question number 1. Consider the following statement regarding the Cabinet Secretary of India. Statement number 1. The Cabinet Secretary is the ex officio head of the Civil Service Board. Statement number 2. The Cabinet Secretary is generally the senior most officer of the Indian Administrative Service. Statement number 3. The Cabinet Secretary is under the direct charge of the Prime Minister. Statement number 4. The Cabinet Secretary has fixed tenure to his office and it cannot be extended beyond the tenure. Here we have to identify the correct statement. One has to note that. So let us discuss the statements. See, the administrative head of the Secretariat is the Cabinet Secretary, who is also the ex officio chairman of the Civil Service Board. Therefore, the statement is right. What about statement number 2? The Cabinet Secretary is generally the senior most officer of the IAS, that is Indian Administrative Service. Therefore, this statement is also right. What about statement number 3? The Cabinet Secretary functions directly under the Prime Minister. Yes, this statement is also right. What about statement number 4? The Cabinet Secretary is appointed for a fixed tenure of 2 years. So kindly note down that Cabinet Secretary has been appointed for the fixed tenure of 2 years. And one has to note that it can be extended. Okay, it can be extended, but here it is given as it cannot be extended. Therefore, this statement is wrong. So kindly note that Cabinet Secretary is appointed for the fixed tenure of 2 years and it can be extended. Therefore, statement number 4 is wrong here. Therefore, we can eliminate D and C, B also. Therefore, answer would be A, 1, 2 and 3 only. See, this is very important. One has to remember. Okay, this is also based on M.Laxmikant. Okay, kindly go through this. So let us move on with the question number 2. The Government of India allocation of business rules in 1961 under Article 77 of the Indian Constitution are made by statement number 1 Prime Minister, that is option number 1 Prime Minister, and option number 2 President, option number 3 Council of Ministers, or Cabinet Minister of the respective department. See, the Government of India and allocation of business under Article 77 of Indian Constitution are made by the President of India. Okay, so kindly note down that also. So this is very important, very important. Since the Government of India allocation of business 1961 are made by the President of India under Article 77, and also note that and the ministries and the departments of the governments are created by the President. Okay, created by the President on the advice of the Prime Minister under these rules. And also note that in the previous question we have discussed about allocation of Cabinet Secretary, right? The business allotted to the Cabinet Secretary under Government of India, that is also comes under allocation of business rule 1961, includes number 1 secretarial assistant to the cabinet, secretarial assistant to the cabinet, and also rules of business, and also rules of business, which comes under allocation of business rule 1961 under Article 77. And also note that the Government of India, that is the Cabinet Secretary, is responsible for the administration of the Government of India and also transaction of business rule 1961 and the Government of India allocation of business rule 1961, facilitating the smooth transaction between business in ministries and departments. One has to know information about this also. So let us move on with the question number 3. Consider the following statement. regarding the governance of India. Statement number 1. All the ministries departments must be headed by the cabinet minister. Statement number 2. All the ministers must have its own department. A department cannot exist without the ministry. Here we have to identify the not correct statement. So that is very important. We have to identify the not correct statement here. See, the cabinet ministers headed the important ministries of the central government like Home Minister and Finance, External Affairs and like that. Not all the ministers or department must be headed by the cabinet ministers. But this is Home Minister, Finance Minister, External Affairs Minister. These are headed by the cabinet ministers. Okay, therefore, here it is given as headed only by the cabinet ministers. No, all the departments may not be or headed by the cabinet ministers. Therefore, this statement is wrong. What about statement number 2? See, the ministers of the state can either be given independent charge of ministers or departments or can be attached to the cabinet ministers. It is not a mandate that all the ministers must have its own department. The minister can be provided independent charges as well as attached department along with the cabinet ministers. But here it is given as all the ministers must have its own department. No, this statement is also wrong. See, some of the departments such as Department of Space, Atomic Energy are under the Prime Minister, not allocated to any ministry. But here it is given as a department cannot exist without the ministry. It exists. Just now we have discussed Department of Space, Atomic Energy portfolio are under the Prime Minister. It does not have a separate ministry. Okay, therefore this statement is also wrong. So based on the discussion, the answer for this question, here we have to identify the not correct statement. Kindly note down all the statements here are not correct. Therefore option D, 1, 2 and 3 are correct. Let us move on with question number 4. The Union Executive consists of the Prime Minister, President, Vice President, Council of Ministers and Attorney General. Yes, see, the Union Executive consists of President and Vice President and Prime Minister, Council of Ministers and Attorney General of India. One has to know about this also. Article 52 to 78 of the Constitutions deal with this Union Executive. Article 52 to 78, that is comes under part 5 of the Constitution. Okay, all the given options forms the part of Union Executive. Therefore the answer would be D, 1, 2, 3, 4, 5. Let us move on with question number 5. With reference to the impeachment of President, consider the following statements. Statement number 1. The impeachment charges can be initiated by either house of the Parliament. Statement number 2. The nominated members of the either house of the Parliament can participate in the impeachment of the President. The Constitution does not define the meaning of phrase violation of Constitution. See, here we have to identify the correct statement with reference to the impeachment of President. See, the impeachment charges can initiated by either house of the Parliament. Yes, whether it is Lok Sabha or Rajya Sabha, they can initiate the impeachment charges. And also the nominated members of either house of the Parliament can participate in the impeachment of the President. One has to note that they do not participate in its election, but they can participate in the impeachment. So remember that point also. Therefore this statement is right. What about statement number 3? The President can be removed from the office by a process of impeachment for violation of the Constitution. However, the Constitution does not define the meaning of the phrase violation of the Constitution. Therefore this statement is also right. So based on our discussion, answer would be D, 1, 2 and 3. See, one has to know the procedure for impeachment of President. When a President is to be impeached for the violation of the constitution, the charges shall be preferred by either house of the parliament. And also, no charges shall be preferred unless the proposal to prefer such charges is contained in a resolution which has been moved after at least 14 days. Kindly remember, which has been moved at least after 14 days notice in writing signed by not less than 1/4 of the total member. 1/4 of the total member of that house has been given of their induction, okay, their intention to move their resolution. And also remember that such resolution has been passed by the majority of not less than 2/3 of the total membership of the house. So that is very important. So these are all very important points. And also note that when a charges has been so preferred by either house of the parliament, the other house shall investigate the charges or causes the charge to be investigated, and the president shall have the right to appear and to be represented at such investigation. And remember that if the result of the investigation, a resolution is passed by the majority of not less than 2/3 of the membership of the house, by which the charges was investigated or caused to be investigated, declaring that charges preferred against the president has been sustained, such resolutions have the effects of removing the president from his office at the time from the date of the resolution is passed. So these are the few important facts related to impeachment of president. Let us move on with question number 6. Consider the following statement with reference to election of the president. The election of a person as president can be challenged on the grounds that the electoral college was incomplete. Statement number 2. All doubts and disputes in connection with the election of presidents are inquired into, decided by the Supreme Court and High Court. Here we have to identify the correct statement. See, the election of person as president cannot be challenged on the grounds of electoral college was incomplete. What do you mean by incomplete? That is, existence of any vacancy among the members of electoral college. Therefore, it makes this statement is wrong. What about statement number 2? All the doubts and disputes in connection with the election of the president are inquired into and decided by the Supreme Court. Kindly note down, it is not by the High Court, only by the Supreme Court, who has the decision, whose decision is final. Supreme Court's decision is final. Therefore, here in this statement, it is given Supreme Court and High Court. Therefore, it makes this statement is wrong. The full answer would be neither 1 and 2, since we have to identify the correct statement. Let us move on with the question number 7. Consider the following statement with reference to the President of India. Statement number 1. The President has no constitutional discretionary powers. Statement number 2. The ordinance can be issued by President with the maximum life for 6 months and 6 weeks. The Constitution does not prescribe any time limit to the President for giving assent to a parliamentary bill. Here we have to identify the correct statement. See, the President has no constitutional discretion, but he shall act on aid and advice of the Council of Ministers headed by the Prime Minister. The President has only situational discretion. So remember that the Constitution has not provided anything. It's only the situational discretion. So here it is given as the President has no constitutional discretion. Yes, this statement is right. What about statement number 2? The maximum life of ordinance can be 6 months and 6 weeks in case of non-approval by the Parliament. That is 6 months being the gap, maximum gap between two sections of Parliament. So therefore, yes, the maximum life of ordinance is 6 months and 6 weeks. This is right. What about statement number 3? The President can exercise the packet veto power as the Constitution does not prescribe any time limit with which he has to take the decision with respect to the bill presented to him for his assent. Yes, the Constitution does not prescribe any time limit. Therefore, this statement is also right. Therefore, answer would be D. 1, 2, 3 is the right answer for this question. Since we have to identify the correct statement, this D is the right answer. Let us move on with the question number 8. With reference to the removal of Vice President of India, consider the following statement. The Vice President can be removed by the resolution of the Rajya Sabha passed by the simple majority and agreed to by the Lok Sabha. No grounds has been mentioned in the Constitution for its removal. See, the Vice President can be removed from the office from before the completion of its term also. The formal impeachment is not required for his removal. He can be removed by the resolution of the Rajya Sabha passed by effective majority. Kindly remember this point. This is very important. Effective majority. So what do you mean by effective majority? One has to know about this. And this is also agreed by the Lok Sabha. So here it is given as simple majority. It makes this statement wrong. Therefore, the statement is wrong. Unlike President, no grounds has been mentioned in the Constitution for the removal of Vice President. Therefore, this statement is right. Answer would be B2 only. Let us move on with question number 9. Consider the following statement with reference to the Deputy Prime Minister. The Deputy Prime Minister shall be a member of Union Cabinet in the Government of India. Statement number 2. The Article 75 of the Constitution explicitly has the provision for appointment of Deputy Prime Minister in India. Here we have to identify the correct statement. See, the Deputy Prime Minister is neither mentioned in the Constitution nor defined by the parliamentary law. So the Deputy Prime Minister need not necessarily be a cabinet minister. Therefore, it makes this statement is wrong. What about statement number 2? See, Deputy Prime Minister is not explicitly mentioned in the Constitution. Therefore, this statement is also wrong. Therefore, here we have to identify the correct statement. Both the statements are wrong. Therefore, answer would be D. Neither 1 nor 2 is the right answer for this question. So, kindly remember this. Let us move on with the question number 10. Consider the following statement with respect to the Prime Minister office. Statement number 1. The Prime Minister office is headed by Cabinet Secretary. The Prime Minister's National Relief Fund and National Defence Fund are operated directly from the Prime Minister office. The Office of National Security Advisor is also part of Prime Minister office. Here we have to identify the correct statement. See, the Prime Minister office is headed by the Principal Secretary. Kindly remember this. Prime Minister office is headed by the Principal Secretary, not by the Cabinet Secretary. Therefore, this statement is wrong. You can eliminate A and D also. You can eliminate D also. See, what about statement number 2? Yes, the Prime Minister heads the National Relief Fund and National Defence Fund. It is operated directly from Prime Minister office. Therefore, this statement is right. Remember that not only National Relief Fund and also National Defence Fund are operated directly from the Prime Minister office. What about statement number 3? The National Security Advisor is the senior official of the National Security Council of India and a chief advisor to the Prime Minister of India on national and international security policies. Yes, this is part of the Prime Minister office. Therefore, answer would be B, 2 and 3 only. Let us move on with the question number 11. Consider the following statement with reference to the Central Council of Ministers. The total number of ministers, including the Prime Minister, shall not exceed 15% of the total strength of both houses of the Parliament. And the advice tendered by the ministers to the President shall not be inquired into any court. Here we have to identify the correct statement. See the first statement. The total number of ministers, including Prime Minister, in the Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. Okay, not both the houses of the Parliament. Kindly remember, it is the Council of Ministers shall not exceed 15% of total strength of the Lok Sabha. Okay, not by the parliament, since the parliament contains both Rajya Sabha and Lok Sabha, but it is total strength of the ministers, including Prime Minister, shall not exceed 15% of the total strength of the Lok Sabha. Therefore, this statement is wrong. What about statement number 2? Yes, the advice tendered by the ministers to the president shall not be inquired into any court. This statement is right. Therefore, answer would be B, 2 only. See, one has to remember or know about Article 74. This Article 74 provides for Council of Ministers with Prime Minister at the head of the aid and advice of the President in the excess of its function. And also, one has to know about the 42nd Amendment and 44th Constitutional Amendment have made that the advice binding on the President. Further, one has to remember that the nature of advice tendered by ministers to the President cannot be inquired in any court. So let us move on with question number 12. The Constitution of India has some provisions for the elections of President, Vice President, Central Legislature, State Legislature, the Governor. See, the President is not directly elected by the people, but the members of the Electoral College. Therefore, yes, this is right. And what about statement number 2? The Vice President, like the President, is not directly elected by the people, but the method of indirect election is elected by the member of an electoral college. Therefore, this is also right. Then what about statement number 3? The Constitution has adopted the system of proportional representation in the case of Rajya Sabha and system of territorial representation for the election of members to the Lok Sabha. Therefore, that is nothing but Central Legislature. And what about statement number 4? This is right. Constitution proposed the system of direct elections to the state legislature. One has to know about this governor. See, the governor is neither directly elected by the people nor indirectly elected by the specially constituted electoral college, as in the case with the president. Also note that this governor is appointed by the president by warrant under his hand and seal. Therefore, this is wrong. The answer would be C, 1, 2, 3 and 4 only. Let us move on with the question number 13. Which among the following is not the functions of the president? Declaration of war on any alien countries, sends and receives diplomats, appointment of all constitutional bodies, make advances out of contingency fund of India. Here we have to identify not the function. Declaration of war on any alien countries, yes, this is the function of president. Sends and receives the diplomats, yes, this is also a function of a president. See, under military powers given to the president, he can declare war or conclude peace subjected to the approval of the parliament. And also remember that the president represents India in international forums and offers and sends and receives diplomats like ambassadors, high commissioners and so on under diplomatic power. Therefore, this is also right. Advocate General of State and State Public Service Commission is appointed by governor, not by the president. Here it is given as appointment of all constitutional bodies. Though Advocate General of States and State Public Service Commission is also a constitutional body which was appointed by the governor. Therefore, this statement is right for this question, since we have to identify not the functions of president. What about statement number D? It makes advances out of contingency fund of India. See, the contingency fund of union government is at the disposal of the President of India, who releases the fund on request of the union cabinet, which later gets an approval from the parliament. The parliament approval is mandatory. This is also function of the president. But this appointment of all the constitutional bodies here given is wrong. So let us move on with the question number 14. Which of the following cabinet committee is headed by the president? But see here, which of the following cabinet is or headed by the prime minister? Okay, we have to identify the Cabinet Committee is headed by the Prime Minister. The Cabinet Committee on Political Affairs and the Cabinet Committee on Security, Cabinet Committee on Economic Affairs. So simply remember these keywords. PSE. Okay. The Prime Minister heads this committee. Parliament, that is Parliamentary Committee, is headed by the Union Home Minister. So therefore 1 is right, 2 is right, 3 is right, 4 is wrong. It is not headed by Prime Minister. Therefore the answer would be C, 1, 2, 3. See, totally right now there are 8 cabinet committees. The Committee on Political Affairs, the Committee on Economic Affairs, and Appointments Committee, and Cabinet Committee on Security, Cabinet Committee on Parliamentary Affairs and Accommodations, Investment and Growth, Employment and Skill Development. See, all the committees except a Cabinet Committee on Accommodation and a Committee on Parliamentary Affairs are headed by the Prime Minister. What about Cabinet Committee on Accommodation, Cabinet Committee on Parliamentary Affairs? See, the Cabinet Committee on Accommodations and Parliamentary Affairs, the accommodation is headed by the Union Minister of Home Minister. Union Home Minister. So remember these points. Let us move on with the question number 15. Who among the following holds the office during the pleasure of the President? Prime Minister, Governor, Chief Election Commissioner, Attorney General. See, the Prime Minister. The term of the Prime Minister is not fixed. He holds the office during the pleasure of the President. However, note that this does not mean that the President can dismiss the Prime Minister at any time, so long as the President enjoys the majority support in the Lok Sabha. He cannot be dismissed by the President, but he enjoys, that is during the pleasure of the President. What about Governor? See, the Governor holds office of the term of 5 years from the date on which he enters upon his office. However, this term of 5 years is subjected to the pleasure of President. Therefore, Governor is also. What about Chief Election Commissioner? See, the Chief Election Commissioner holds the office for the term of 6 years. And also remember that until the age of 65 years, whichever is earlier, the Chief Election Commissioner is provided with the security of the tenure. He cannot be removed from his office except in the same manner on the grounds as the judges of the Supreme Court. Therefore, he does not comes, that is Chief Election Commissioner office does not the pleasure of the President. Therefore, this statement is wrong. You can eliminate D. What about Attorney General? See, the term of the Attorney General is not fixed by the Constitution, but he holds office during the pleasure of the President. Yes, this is right. Therefore, answer would be C, 1, 2 and 4. Let us move on with the question number 16. Consider the following statement. The Governor of a state and Lieutenant Governor of the Union Territory can reserve any bills for the consideration of the President of India as it's their discretion. Statement number 2. The Governors or Lieutenant Governor assent to the bill is not required if they reserved for the President of India. See, this is very important question related to current affairs also. So one has to remember this point also. Let's discuss this. Consider the following statement. Okay. When the bill has been passed by the Legislative Assembly of the state, or in the case of state having the Legislative Council, has been passed by both houses of the legislature of the state, it shall be presented to the Governor, and the Governor shall declare either that he assents to the bill or that he withholds assent therefrom, or that he reserves the bill for the consideration of the President. Therefore, this statement is right. What about statement number 2? When the Governor reserves the bill for the consideration of the President, he will not have any further role in the enactment of the bill. If the bill is written by the President for the reconsideration of the House and is passed again, the bill must be presented again for the presidential assent only. Therefore, if the President gives his assent to the bill, it become an act. This means that assent of the governor is no longer required. Therefore, this statement is also right. Answer would be B, 1 and 2. Let us discuss question number 17. Consider the following statement. Council of Ministers is collectively responsible to the Lok Sabha. And then Cabinet also have members apart from Council of Ministers. Cabinet decisions are binding on all Council of Ministers. C. The Council of Ministers shall be collectively responsible to the Lok Sabha in general. Okay, according to the 75, Article 75. Responsible to the Lok Sabha, but in general responsible to the Parliament. This provision is the foundation of the parliamentary system of government. Therefore, this is the right statement. The Cabinet includes only Cabinet Ministers, which is part of the Council of Ministers. But here it is given as have members apart from the Council of Ministers. Therefore, this statement is wrong. You can eliminate B and D. And what about statement number 3? Cabinet directs the Council of Ministers by taking policy decision which are binding on all the ministers. Yes. Therefore, this statement is right. The answer would be C, 1 and 3 only. Let us move on with the question number 18. Consider the following statement. Okay, in the situation, in X, the Lok Sabha elections, several parties were contesting. They were involved in several rallies to spread their program. Campaign. I ended at 6 p.m. 2 days before election. Country went voting on the polling date, on the date of declaration of the result. Single largest party or alliances got 205 seats. No party or alliances approached the president for formation of the government. In the above situation, which among the following decisions shall be taken by the president? See, the total number of the seats in the Lok Sabha is 543. The party or coalition needs to win one seat above this of 50% mark. Okay, above the 50% mark, which means are 272 seats to secure majority. When no party is able to secure a majority in the election, this means it's nothing but unparliament. So this is also very important. So one has to remember and also go through about unparliament. In this case, the parliament, okay, the president may invite the leader of the single largest party or alliances in the house to form the government. In the alternative way also, the president may invite a combination of parties who, in his opinion, might be in the position to command a majority in the house. So therefore, may call single largest party to form the alliance, yes. Calls any person to form or approve majority and dissolve the Lok Sabha and recommend re-election, no. So this is also right. So therefore answer would be D, either A or B. Calls any person to form the government and approve majority. Let us move on to question number 19. The oath of office to the president is administered by the, it's a straightforward answer, Chief Justice of India. C. The oath of the president, office of the president is administered by Chief Justice of India, or in his absence, senior most judges of the Supreme Court, senior most judges of the judge of the Supreme Court available. Any other person acting as the president or discharging the functions of the president also undertook the similar vote of or affirmation. Let us move on with the question number 20. What type of veto is not enjoyed by the president? Packet veto, substantive veto, qualified veto, absolute veto. See, the veto power enjoyed by the executive in modern states can be classified into 4 types. Absolute veto. What do you mean by absolute veto? That is withholding assent. Okay, this is nothing but withholding the assent to the bill. Okay, withholding the assent to the bill passed by the legislature. What about qualified veto? The qualified veto is nothing but which can be overridden the overridden by the legislature with higher majority. So this is important, higher majority. What do you mean by suspensive veto? Which can be overridden by the legislature by the ordinary majority. By the ordinary majority. And what about absolute veto? We have discussed. What about packet veto? So see, the packet veto is nothing but no action on that bill passed by the legislature of the above four. See, the President of India. See, the President of India has three veto powers. One is absolute veto, and suspensive veto, and packet veto. In short, ASP. See, there is no qualified veto in the case of Indian President. See, this qualified veto is possessed by American President, not by the Indian President. Kindly note this. This is very important. That is, the overridden by higher majority, it is possessed by American President, not by the President of India. Let us move on with the question number 21. In which of the following matters the state government can exercise their executive powers in normal scenarios? Subject under state list, subject under union list, subject under concurrent list, residue subjects. See, the question is the state government. So that is the key here. The question is about the state government. Subject under state list? Yes. Subject under union list? No. Strictly no. Subject under concurrent list? Yes. Under normal scenario, the state government can exercise the executive powers with respect to concurrent list also. What about residue subject? The residue subject is not given to the state. Therefore, this is wrong. Therefore, answer would be 1 and 3. C. 1 and 3 only. See, the states shall extend its executive power only to its territory on subject matter over which it has legislative competence. So, state has exclusive executive powers over matter enumerated in the state list or list 2 of the 7th schedule, that is concurrent list. Subjects under union list remains under the jurisdiction of central government. See, the residue powers are the discretion of union, not with the state. Therefore, this is very important points related to this question. Let us move on with question number 22. Consider the following statement with reference to the Attorney General of India. The Attorney General of India must be a person who is qualified to be appointed as the judges of the Supreme Court. The Attorney General has the right to audience in all the court in the territory of India except Supreme Court. See, the qualification of Attorney General of India is it requires to be eligible for becoming judge of the Supreme Court. Therefore, this statement is right. What about statement number 2? See, Attorney General has right of audience even in the Supreme Court. Therefore, this statement is wrong. The answer would be A1 only, since we have to identify the correct statement. Let us move on with the question number 23. Consider the following statement with reference to the election of the Vice President. The Vice President is elected by the members of Electoral College consisting of only the elected members of the both houses of the Parliament. Statement number 2. He should be qualified for election as the member of the Rajya Sabha. Here we have to identify the correct statement. See, the Vice President is elected by the member of Electoral College consisting not only the elected member of both houses of the Parliament. Even nominated members too can take part in electing Vice President. But here it is given as only. Therefore, this statement is wrong. What about statement number 2? He should be qualified for election as the member of Rajya Sabha. Yes. See, what are the qualifications to become a Vice President? Number 1, he must be a citizen of India. He must be a citizen of India. And number 2, he completes the age of 35 years. And number 3, he is qualified for the election of members of Council of States. That is nothing but Rajya Sabha. So, with this, we are moving with the question number 24. Consider the following statement. all the decisions of the Council of Ministers relating to the administration of the Union must be communicated to the President. And statement number 2, the President can call for information relating to the proposal for legislation. The President can direct that any matters on which decision has been taken by the minister should be placed before the Council of Ministers. Statement number 4, the President has the right to address and send messages to the Council of Ministers to elicit specific information. One has to know about Article 78. Okay, this Article 78 can be seen in two perspectives. One is perspective of PM. PM is nothing but Prime Minister. So what are the duties of Prime Minister? And from the perspective of President. So these are the very important points. There are duties and rights. See, from perspective of Prime Minister, to communicate to the President all the decisions of the Council of Ministers relating to the administration of affairs of the Union and the proposals for legislation. Therefore, this statement is right. What about statement number 2? C. Yes, the President can call for information relating to proposal for legislation. And also note that to furnish such information relating to the administration of the affairs of the Union and a proposal for legislation as the Prime Minister may call for. And also remember that if the President is so requires to submit for the consideration of Council of Ministers any matters on which the decision has been taken by the ministers. Therefore, the President can direct on any matter. Therefore, this statement is also right. What about statement number 4? See, the President under Article 86 can send a message to Parliament, not to the Council of Ministers. Remember that the President, according to the Article 86, can send a message to Parliament. Send a message to Parliament. Okay. And not to the Council of Ministers. Therefore, this statement is wrong. Therefore, answer would be C, 1, 2 and 3. So, let us move on with question number 5. Today's last question. Consider the following statement. The President can function without the Union Council of Ministers. The Solicitor General is the highest legal authority of the Union government. The Union Council of Ministers can function for sometimes even after the death or resignation of the Prime Minister. In the absence of Prime Minister, only the Home Minister can preside over emergency meetings of the Union Council of Ministers. Here we have to identify the correct statement. See, according to the Article 53, state that the executive power of the Union shall be vested in the President. And also remember that Article 74 says that there shall be the Council of Ministers headed by the Prime Minister to aid and advise the President. Therefore, the President cannot function without the Council of Ministers. Yes, this statement is right. Remember, he cannot function without the Union Council of Ministers. Attorney General is the highest legal authority of the Union. Therefore, not the Solicitor General. Therefore, this statement is wrong. We can eliminate C and D. And what about the remaining statements? The Union Council of Ministers can function for some time even after the death or resignation of the Prime Minister? Strictly no. See, again, the Article 74, we can deduce the Council of Ministers cease to exist where there is death or resignation of Prime Minister. Therefore, this statement is wrong. In the absence of Prime Minister, here it is given as only the Home Minister. See, any cabinet minister can preside over the meeting of Council of Ministers in the absence of Prime Minister. Therefore, this statement is also wrong. Therefore, answer would be A,